Hello, I'm Tamara Covington. I'm your instructor for this semester of special education law, and this is your first experience with the video blog posting or the vlog posting for case law reviews. And I am going to show you primarily what I would like to see in your video blogs and give you some additional information regarding the case law for this week, Brown versus Board of Education, Topeka, Kansas. So to begin with, I would like to provide some historical perspective or context on Brown v. Board of Education. And the American legal system allows for multiple sources of law, including constitutional law, legislative or regulative law, and case law, which are decided in the American court systems. And as you are aware, there are multiple levels of court systems, including the local level, the state level, the district level, the circuit level, and the United States Supreme Court level. And Brown v. Board of Education was heard before the United States Supreme Court in 1953, and the decision was handed down by Chief Justice Warren in May of 1954. And although Brown v. Board of Education was not a disabilities claim, it was a claim on what is considered equal in the eyes of the law as far as education is concerned. And so in order to be able to provide some context for that, you have to look at the compulsory education laws that were ratified by all 50 states by 1918. And those compulsory education laws indicated that education, although not in the Constitution, was a property right given to people by state law. And so as a result of that, it's covered by the 14th Amendment of the U.S. Constitution, called the Equal Protection Clause, which states that the United States government cannot remove your property without due process of law. So therefore, education has become a property by citizens of the United States. So Brown v. Board of Education was tried during the civil rights movement in the United States, and it led to constitutional protections for minorities. In addition, it became the major underpinning for further civil rights action, according to it affected many aspects of educational law and procedure. In the Brown ruling, Chief Justice Warren opined that education was, quote, one of the most important activities of government, according to Nikki Murdoch in Special Education Law, 2014. The plaintiffs in Brown versus Board of Education argued that separate was inherently unequal and that it violated the right to the property clause of the 14th Amendment due to compulsory education laws. The cases heard in Brown v. Board of Education came from a number of states, including Kansas, South Carolina, Virginia, and Delaware. In each case, persons of the Negro race sought the aid of the courts to obtain permission to attend the public schools of their choice on a non-segregated basis. This segregation was alleged to deprive them of equal protection under the laws under the 14th Amendment. In addition, state and sanctioned exclusion was unconstitutional and denied minority children equal educational opportunity, which falls directly in line with the 14th Amendment equal protection doctrine. The lower courts in Brown v. Board of Education used the court ruling of Plessy v. Ferguson, 1896, which stated that segregated schools were substantially equal. As a result, Chief Warren wanted to consider public education in light of its full development and its present place in American life throughout the nation. Only in this way did he feel they could determine if segregation in public school deprives those plaintiffs of the equal protection of the laws. Chief Justice Warren determined that the reason for this ruling was to ensure that states were not allowed to have their own set of criteria for what is considered equal and non-discriminatory practices, and that the nation as a whole needed to have a guiding precedent such as separate is unequal to ensure that all students across the United States were ensured equal educational protection under the law. Chief Justice Warren further argued that segregation of white and colored children in public schools has a detrimental impact on colored children. The impact is greater when it was sanctioned by law, for the policy of separating the races is usually interpreted as denoting the inferiority of the Negro group. As a result, they concluded that in the field of public education, the doctrine of separate but equal has no place, and separate educational facilities are inherently unequal. The resulting impact on the educational institutions as far as policy, practice, and procedures are that public schools are no longer able to even consider segregating students based on a class such as race, gender, or disability. Plessy v. Ferguson was overruled by Brown v. Board of Education. And so the law of the United States now is that separate is not equal, and that states must provide equal educational opportunity for all students regardless of who they are or what might separate them from others. This is important to understand because many future disability claims and discrimination claims are based on this premise set forth in Brown v. Board of Education, with separate being unequal. You will find that many of the court cases and legislation put forward by the United States courts as well as Congress operate now under the premise that separate is in fact not equal. By adopting the doctrine of separate is not equal through Brown v. Board of Education, the Supreme Court established the foundation for opening the public school doors to all students across the United States, regardless of race, gender, or disability. Brown v. Board of Education reversed Plessy v. Ferguson, and it is regarded as a seminal case for non-discrimination of individuals within the public school system in a protected class such as race, gender, or disability. As an entity of the federal government, public schools are required to follow federal laws. This distinction is critical in further understanding the federal education policy and legislation and how it provides the structure for the public school systems today. As a result, states are no longer able to have laws setting up criteria that discriminate against individuals in public schools. Subsequently, local public school districts could not prevent students from enrolling in their schools based on race or gender, again, or disability. The ruling in Brown v. Board of Education limited local control of the public school system by extending the federal constitutional protections of the right of property to all students. Education is commonly viewed, as I've stated, as a property right under the 14th Amendment, and as such cannot be restricted in discriminatory ways without due process. To receive federal funding, states cannot have laws that violate the constitutional rights of its citizens. Many viewed this move as the centralization of power with the federal government over public education, this move being the ruling in Brown v. Board of Education. This is a concept that many people feel has continued with Common Core standard requirements along with high-stakes accountability testing. It is a political issue that the current presidential administration is attempting to reverse through school choice initiatives and the reduction of direct federal funding to states increases in more local control. Many of the public educational advocacy groups, including the National Education Association and the American Federation of Teachers, formerly known as the National Federation of Teachers, strongly oppose the Department of Education's Secretary Betsy DeVos's proposal regarding federal funding in school choice. Randy Weingartner, AFT president, writes, "The Trump and DeVos agenda takes a meat cleaver to public education and directs funds to vouchers, private schools, and charter schools at the expense of the public school students across the country," in his email dated May 15, 2017, entitled, "They're Coming for Our Public Schools." Conversely, Montana Senator Steve Daines has championed local control over public education in Washington, D.C., according to his proposed education plans and voting records. In an article from the Billings Gazette on January 6, 2017, Daines is quoted as saying, "We want the parents and teachers and students to lead in education instead of a bunch of D.C. bureaucrats." Daines' plan called A+, an alternative to Every Student Succeeds Act, which replaced No Child Left Behind last year, was hailed for expanding local control. But Daines argued that the ESSA, didn't go far enough and voted against it. Billings Gazette, January 6, 2017. Understandably, this is a belief that many find gravely concerning due to the federal actions that was necessary to release the grip of states educating their students, quote unquote, as they saw fit, as Justice Warren wrote in Brown v. Board of Education. The fear is that returning control to public education to state and local entities takes the country back 70 years. Regardless of each person's take on the situation, it is clear that the implications of Brown v. Board of Education remain relevant in 2017. As you learn about additional federal legislation related to anti-discriminatory practices, keep in mind how the process originally started in public education well before the civil rights movement was in full swing. So again, the concern here is that by returning to school choice initiatives and voucher initiatives and local control, that states will limit the rights of students under state legislation and therefore violate the 14th Amendment clause of the United States Constitution. So the question for this week becomes, how does the American public school system compare in relation to the public school system of the 1950s? And how is it different?